Ari, you were talking about what you think this case is really about. I wanted to give you an opportunity to finish that thought.
Yeah, and it's much more interesting than the legalese of it, Christine. What the Quebec Court of Appeal said, again, using some of the language from the trial judges, in a free and democratic society, let's use those words, free and democratic, us three judges are going to strike down what Parliament duly elected. Again, we can't use the name Harper because it's sort of like Voldemort, but what they decided in 2011, we three are going to say is cruel and unusual to a young man like Bissonnette, who only committed this crime in 2 minutes. He's not a serial killer, he's not a hitman. And Christine, here's the language that I think people need to know. They said, and they adopted the trial judge that said Canadians would consider abhorrent and intolerable any sentence denying Bissonnette a reasonable prospect of release on parole in the last years of his life. I wonder how many ordinary average Canadians were polled on that.
Professor Millward, I want to turn to you because one of the things we've been talking about is what is cruel and unusual, and the court's going to be looking at that in this case. So can you explain to our viewers what cruel and unusual means and where it's protected in our charter, the prevention of cruel and unusual punishment?
Okay, so there are certain things that the right against cruel and unusual punishment prohibits. One is corporal punishment, like caning. Another one is the death sentence. Now, there is also a theme that's been picking up in recent years, and that is the grossly disproportionate sentence, where a sentence is too long, accounting for the accused's personal circumstance and the extent of the harm he did, and numerous other factors. And this has come up quite frequently in cases involving mandatory minimums. Now, the way that courts look at this is if there's reasonable hypothetical, there's a certain kind of scenario where you can actually expect it to come up with a certain amount of frequency. And judges may, for that reasonable hypothetical, might want to go with something like a conditional sentence or prioritize rehabilitation. But the mandatory minimum removes that judicial discretion, doesn't give the judge any room. It's in that kind of situation where courts have frequently been willing to invoke the charter right against cruel and unusual punishment and strike down mandatory minimum laws. The problem that I see here with the Bissonnette case is that the provision that my colleague Ms. Silver indicated is entirely discretion-based. So the provision itself says the jury doesn't have to make a recommendation about whether to stack sentences or not, but they can. And even if the jury does make a recommendation, the judge can take that recommendation into account, but it's up to judicial discretion about whether to actually stack sentences or not. So just to anticipate the Supreme Court, there's a part of me that thinks that the Quebec Court of Appeal judgment stands on pretty shaky ground once it's going to come to the Supreme Court. And then the Supreme Court might surprise us, but that's my initial hunch.
And we actually, on these mandatory minimums, we did a show a few weeks ago about that very topic. So I'd encourage anyone who's interested to check out that episode, which was also great. Professor Silver, I want to turn to you about something Mr. Goldkin has raised. So every human life has infinite and incalculable value. So does letting a killer, a convicted killer, serve one prison sentence for ending multiple lives, does that remove some moral culpability?
Well, first, let me say that there's no question that every life that is taken matters. And as you say, you can't put a value on a life. And that tends to be the criticism with this law, that it does attempt to put a numeric value on the life. And the other criticism that is reflected in the Court of Appeal decision is that these consecutive parole and eligibility provisions, because they stack, 25, 50, 75, 100, 150, cannot fulfill this government's objective that this law is to count every life that is lost. So that's been part of the criticisms, although I have to say the Alberta Court of Appeal has no problem with the stacking of parole and ineligibilities, and certainly doesn't buy into those arguments. But as to your question about blameworthiness, it doesn't remove moral culpability, it's there. The conviction is there, that is the blameworthiness part. of the elements of those crimes have been found, and a sentence is imposed. But I think there's a more serious problem and a more serious question, which is, does this kind of sentence promote an offender's sense of responsibility? Does it sufficiently denounce the conduct?